Our next speaker is a graduate of University of Wisconsin in Madison, and the University of Miami School of Law, where he was order employed. He has been actively involved in the legal community. He served as the Florida Justice Association chairman of the Insurance Committee. He's been a member of the Executive Committee. He served as the Secretary of Treasurer, President-elect, and finally the President of the Florida Justice Association. He has over 18 cases that have been reported. He is the manager of Zebersky & Payne, where he practices in the areas of class action, insurance coverage disputes, torts, products liability, complex commercial litigation, and wrongful death. Much like all of the other speakers who have come before you today, I have a personal story about Ed Zebersky. He's also an excellent trial lawyer. Stuart and I tried a case with Ed in Broward County in 2010, last year.
Yeah.
And I can say that his legal skills are second to none. In Broward, he's known, in South Florida, he's known as the class action go-to guy. He's very well respected, but it's interesting, walking through the hall with him in Broward is like walking with somebody who's running for mayor. He knows everyone, and instead of him walking up to judges to say hello, the judges actually come to Ed to talk to him to see how he's doing. So he's kind of a celebrity in that courthouse, and but that's only because of how highly respected he is as a trial lawyer, as an advocate for his clients. So it's my pleasure to introduce to you our next speaker, Ed Zebersky.
Okay. Well, Scott, thank you. I mean, that was extremely nice of you. All lies, of course. But, you know, I'm actually really honored and thrilled to be here today to talk at the Ratzan Law Group CLE seminar. I'm honored because one of my best friends is Stuart Ratzan. I met Stuart when we were first-year law students at the University of Miami over beers, where we spent many hours talking about what we wanted to do with our lives and what kind of lawyers we wanted to be. And I think that it became crystallized, for me at least, and I think for Stuart too, when we took our first con law class and we realized how fragile our rights really are. And on a porch one night in Coconut Grove, we both decided that our most likely path was going to be trial lawyers, working for the little guy against corporations and people who've been wronged, and that's what we have become. Stuart, which makes me just so proud today, is one of the preeminent medical malpractice trial lawyers in the country. And I can say I knew him when that seed germinated. And you know, so that's why it's such an honor for me to be here at his first CLE seminar that he put on for his law firm. Now, I'm here today to talk to you about my love, which is class action law. Instead of medical malpractice, where I'm representing an individual against a hospital or a doctor that did something wrong, I represent those same type of individuals against a major corporation, an insurance company, someone who has been equally as grieved, but it's been done time and time and time again over periods of time where the company has cheated people out of millions and millions of dollars. So truly, when you look at David and Goliath, the class action mechanism allows David to look Goliath right in the eye with a slingshot and sling that shot right at Goliath and take him down. Now, when I looked at what we needed to talk about today and what the seminar was all about, it was about the practice of class action law. So today, I'm here to talk to you about how I became a class action lawyer and about my practice and the things that I look at and that are important to me in my practice and essentially how I practice. I encourage everyone out there to ask any questions that you may have as I go through this lecture, because quite honestly, I changed it this morning from what I was originally going to speak about, which was the technical aspects of class action law. So please feel free to ask any questions at any time. The first thing that I'd like to talk about is the class action practice and the business model that you need to have in order to be a class action lawyer. as lawyers, while it's great to say that we're out there to represent the little guy against the big guy, you know, the bottom line is we need to be able to sustain a practice in order to do that. And you need to have the proper business model in order to be able to attain that type of success. So before anyone goes out and says, I'm going to be a class action lawyer, you really need to go out with eyes wide open as to what it takes to be a class action lawyer. And in order to do that, you need to know what the class actions are, what type of money it's going to take to fund a class action, how long it's going to take for a class action to begin and when it ends. And when it ends, it doesn't necessarily mean you get paid. It may be a couple of more months or even years down the road before that happens. So as we go through this conversation, I think that you need to look at this from the standpoint of, does this type of business model make sense for you? And if it does, then it's a great way to practice law. You know, in order to do a class action right, you need to equip your office in a way where you're able to synthesize a tremendous amount of documents at any given time, because the amount of paper that comes into your office is voluminous. The last case that I worked on, which we recently resolved, had over 1 million documents come in. And they all need to be reviewed. They all need to be cataloged. They all need to be organized in a way that you can readily access them at any point in time. So my suggestion is, if you want to get involved in class action practice, that you develop a great computer system. And you develop a computer system that has specific software to deal with a voluminous amount of documents. The other thing that we see in class actions is that there's a heck of a lot of writing that goes on. And there's a lot of legal research that you must do. So a Westlaw or Lexis is absolutely essential, where you're not only able to look for cases in the state of Florida, but really across the country, because a lot of the class action law you find in federal courts in Missouri or Nevada or places other than the Southern District. So a computer system is really important as well. Now, you know, as with any other practice, one of the important aspects of a class action practice is client intent. You know, you need to pick the right case, because if you pick the wrong case, like with any medical malpractice case or products liability case or commercial law case, you can spend hundreds, if not thousands of hours and wind up with nothing. And a firm, especially a small firm, cannot absorb that type of loss very often, if at all. So when you look at cases, especially in a class action framework, you need to take a look at what you think you're actually going to be able to win versus what type of case may look good, but eventually is going to be a dog. And before I got up here, Brian Eskenazi actually was talking to me about that. You know, one of the things that he wanted to ask me was, what is a good class action and what is a bad class action? And before I go further, how many people in here have handled a class action lawsuit before? What kind of case have you handled?
Statutory violations.
Great. What kind of statutory violation?
Both at the federal level and the state level, credit card receipts.
A TILA case?
No TILA.
Okay. Someone else raise their hand in the back?
Fair Labor Standards Act opt-in class action.
Wonderful. Those are the types of cases that are wonderful class actions. You know, what I told Brian was, how do you identify a class action? Well, you identify it by having someone come to you and say, I was wrong. And most great class actions are the ones where a company has cheated someone out of not millions of dollars or hundreds of thousands of dollars, but maybe they're cheating people out of hundreds of dollars or thousands of dollars, because the company has a pattern in practice or a way that they do business that's unlawful. Statutory violations are great cases. They're great cases because from a class perspective, there's enough common elements there, the claims are typical enough, and the individual issues do not predominate to the point where you're going to be able to get a class certified. Now, I'll give you a couple of examples of cases that I've handled which are good, and then I'll describe some of them that were bad. The most recent case that I resolved was against Lloyd's of London. Now, most people think of Lloyd's as an insurance company. It happens to not be an insurance company. It's an insurance market. It's a little bit different and made it a little bit more squirrely and difficult to resolve, but the bottom line is we claim that Lloyd's of London, all of the syndicates that operated under Lloyd's that were selling property insurance in the state of Florida, were violating certain provisions of Florida law with respect to charging a separate hurricane deductible. And the lawsuit was about a violation of Chapter 627.701 and whether or not the deductible provision inside of that policy was actually valid. And our argument was it was not. And eventually there was a settlement, and we're waiting for a preliminary approval in front of Judge Altanaga in the Southern District. In your packet, I handed you another similar case that I settled recently, which is the Arch Specialty case, which was based on the deductible provision, but also they failed to have a proper coinsurance penalty. So in addition to the deductible claim, we had a coinsurance penalty claim. And you can take a look at the settlement agreement and see what that case is all about. But those types of cases are perfect class actions. Why? Because they're simple. You look at a form contract, and either the contract complies with the law or it doesn't. There's not much factual inquiry that needs to go into whether or not the statute is followed or whether the statute complies. And those are the cases that are normally wonderful. Let me give you another example of one that was wonderful. And I started out as a class action lawyer by mistake. Back in 1994, I had a PIP suit. And we filed a PIP suit against a company called Fortune Insurance Company. Does anyone in here remember Fortune? Okay, Fortune might have been one of the worst insurance companies that I've ever had to deal with. They wouldn't pay on any claim. So one day in one of my auto cases, we went ahead and we filed a lawsuit against them to pay their PIP. And they didn't pay it. Well, after we filed the lawsuit and served them, they paid the amount to my client. So I called them up and I said, you know, statute 627.428 says you got to pay my costs and fees. I'll go away if you just pay my costs. And you know what they said? No. So I sat down and I thought to myself, well, how am I going to get my costs paid? And I looked at the PIP statute, and I found that in addition to the amount of money that they needed to pay for the underlying claim, they needed to also pay 10% interest. And I remember looking at that statute and saying, aha, I'm going to get the 10% interest. And now, because they didn't want to pay me my costs, I'm going to make them pay me fees, and I'm going to take it to trial. And as I was thinking about the case, I realized that Fortune Insurance Company didn't just not pay me the interest. They didn't pay anybody the interest. And I learned that after several conversations with other lawyers and other medical providers. And that brought me back to first year of civil procedure, where Professor Massey told me about Rule 23, and I filed my first class action, not just against Fortune, but against every single major auto insurer in the state of Florida, because none of them were paying interest. And today, they all pay interest. So that's the power of a class action, and that's really how I got